And my client, the SIU, deals with or has to deal with the most egregious forms of misconduct, and that is the looting of state coffers, which is preeminently in the public interest, which is preeminently a matter for the Constitution. So, my lady, the rest of our heads on remedy obviously is what we argue is in conformity with the Constitution, because then we go on to 1721B for the relief that we seek, and whether the relief must be just and equitable, and that depends on the facts of each case. We made out the case, we submit, my lady, that Echo Green knowingly circumvented instruction note 8 by doctoring their CSD profile, for example, through Mr. Shivambu and Ms. Bimji. They knowingly operated as a front for Mr. Buthelezi to benefit from the contract. And we submit in these circumstances.
Just assist me on the law, Mr. Arons, because your opponents will be arguing that all pay doesn't say what you say it says.
Yes, my lady.
So I've not seen the final order in all pay, because they make out the case that they were not deprived of their profits. I've not seen that final order. All I recall is that there was a structural order. There was a structural
It was a structural.
Yeah, but I'm not sure if there was a final order depriving all pay of its profits. Perhaps you can deal with that in your supplementary heads, and,
yes, my lady,
and also provide such an order if it exists.
Yes, my lady. So we will do that, my lady. Obviously, the facts of all pay were entirely different. The court was really.
But there was no bad faith in all pay, right?
No, not at all. And
there was no bad faith. There was no the kind of allegations made here were not in all pay at all, right?
Yes.
There was no evidence that no allegation that anyone benefited, that there was malafide. It was just simply a question of non-compliance with procurement laws and regulations.
And in fact, your ladyship will recall that the relevant minister at the time even supported all pay, or didn't object to their case in the Constitutional Court.
Well, they normally stay clear of these applications.
Like the Department of Transport tried to do in this case.
Yes, they normally just stay clear.
Yeah. Yes. But so that's clearly a distinguishable feature to the all pay case, and we submit that we've made out a case here of malafides, ulterior purpose, and fraud in this case.
Yeah, and the jurisprudence we've adopted here is the interpretation of all pay that you prefer, the Mott McDonald's approach. That's the one the tribunal has adopted, and it is being challenged, I must say, in an appeal in the Bait Bridge matter, Caledon River Properties. I think that appeal is still going through.
Still pending.
It's going through the courts, yeah.
So, my lady, those are our submissions, that primarily that the money should be returned, and alternatively, they must be they must return the profits they made. We did, I think we did post a draft order on case lines a while ago.
You did. As I said, I've not studied it because I expected it to mirror what's in the notice of motion. So what are you moving for? So, you can just deal with the remedy.
So we've moved as far as remedy is concerned for the contract prices for that to be returned. And in the case of C squared, their profits. And we've set that out in our heads, the reason for the disgorgement of profits.
What's your authority for the remedy you seek against Eco Green? I seem to have missed that. Because I've not come across a case where, even where a finding of malafides or fraud is made, then a supplier is ordered to repay the full purchase price when a government department retains the goods supplied.
We submit, my lady, on the basis of the common law relating to contract, which is that.
Yes, I'm asking in these types of cases. There's been numerous other cases where there was evidence of malafides, criminal conduct, where a supplier has never been ordered. I mean, I'm thinking in this tribunal, off the top of my head is the Hamilton matter. I don't know if you remember that matter.
Yes, my lady.
Where there was evidence of 90% of the tender the amount paid by the National Department of Health actually was traced to have personally benefited him. And even in that case, he wasn't ordered to repay the full amount. In fact, that the SIU didn't. Perhaps it's distinguishable because that's not what the SIU asked for there.
Well, we asking for it here because effectively these parties induced by fraud and deception the department from paying over to them public monies, which they were not entitled to.
Yes, but what about the benefit? What about the benefit that the department derived from the contract? Is it nullified by a finding of malafides or fraud, if I make it?
Well, I mean, I don't think we have any explanation from the department that the supply of these goods actually benefited the public. We know that.
But it's not your case that the goods were not delivered. It's not an issue. The goods were supplied, department paid.
Yes, my lady.
Okay, assist me with authority. If you want me to rule in that direction, then you must assist me with authority. I don't think it's sufficient for you to say simply on the basis of the common law.
Thank you, my lady. If we may address you in reply on that.
Okay, thank you.
Thank you, my lady.
Thank you. Mr. Fobler.
My lady, may it please the court. My lady, I have taken some cue from your ladyship's engagement with my learned friends for the SIU as to what your ladyship views is the crux of the matter. And with your leave, I intend to deal only with those aspects because I believe But Your Ladyship, those are the burning questions or the vexing ones. In some instances, in some instances, we would submit certainly not. But I addressed then accordingly, my lady, 8 issues, and I will do so as briefly as I possibly can. Please don't consider this, my lady, as an abrogation of what we have argued in our heads. I'm not going to repeat, and I'm certainly not going to regurgitate what our heads say, but it is there for the reading. We hope that it was of some help in Your Ladyship's, no doubt, surgical-like precision in your preparation for the matter. My lady, firstly, this deals with the first 2 points that I want to make, just as general introductory remarks as to the approach that we submit Your Ladyship is to follow this morning, or this afternoon already, I beg your pardon. I'd like to refer firstly to what All Pay says, both All Pay 1 and All Pay 2, and then probably superfluously just refer the court to legal truisms dealing with the approach of the court in motion proceedings where there is a dispute of fact. That is necessary because in many instances, and with great respect, the SIU has got the facts of the matter wrong, and I will address that in due course. But I intend to deal with those 2 issues firstly. Then thirdly, my lady, I intend to deal with the CSD argument and the interpretation that the SIU proffers. Fourthly, I intend to show to Your Ladyship with reference to the record that there indeed was no overcharging on the gloves issue. Your Ladyship will immediately realize that what I'm addressing is the exceptions as catered for in Instruction Note 8. And I do so obviously on the basis of we respectfully agreeing with Your Ladyship, if that is your finding, that it was not mandatory in its application. Fifthly, my lady, we deal with this persistent argument on the part of the SIU that Your Ladyship is to factually find that the other suppliers, those on the list of Annexure A, were not approached at all. And the way in which the SIU asks for such a finding, and we point the court's attention respectfully to certain extracts of the record showing that argument respectfully is wrong. Sixthly, my lady, I deal with the extension of the C² contract. That was, Your Ladyship will remember, for the transport services. It had become known that Eco Green and Mistralog were unable to deliver, and as C² was going there, in any event, they were asked whether they would cart the Eco Green and Mistralog supplies as well. And the SIU's insistence that that was unlawful as well, given what our Constitution says. Seventhly, my lady, there was a submission made that, and this was in answer to a question Your Ladyship had asked of my learned friends, was there a request for quotations? And the answer was no. And if I misheard the answer, and I apologize, my learned friends will correct me in reply. We intend to show that that is wrong with reference to the document itself. In other words, there was a request for quotations. And eighthly and lastly, in ex abundante, my lady, we stress this because in our submission, the court should not go there at all. We deal with the remedy that is to be applied, if any, and just certain legal propositions pertaining to that. So if Your Ladyship will permit me, firstly, to deal with what All Pay, and I'm talking about All Pay 1.
Mr. Grobler, just from a structural perspective, I think it makes sense for you to deal with All Pay together with the remedy.
I will indeed do that. Thank you for the direction, my lady. But there are 2 All Pay decisions. They are commonly known as All Pay 1 and All Pay 2.
Yes.
All Pay 2 dealt with the remedy, and All Pay 1 with the approach that a court is to adopt in matters of review of state procurement. So what I intend to do is I intend to deal with All Pay 1 firstly, and then in dealing with the remedy, then dealing with All Pay 2.
All Pay 2, I see. Okay. I thought you wanted to rely on All Pay in relation to the remedy only. That's fine. You may do so.
Thank you for clarifying that, my lady. My apologies for mispronouncing. I will also refer Your Ladyship to the Pomela decision, which was recently dealt with, the SIU versus Pomela decision. It's the SCA case where the SCA said, that there was in that instance in regard to those facts, there was no obligation to make a repayment of anything, but I'll deal with that. it was mentioned in my heads. So then, with your ladyship's leave, all pay one. We submitted, my lady, in our heads that a red flag kind of approach is not to be followed. That is to say that the approach of a review court to matters of state procurement and in general administrative law reviews is not to trawl through a record and see if one can find irregularities. And once an irregularity is found, to raise the proverbial red flag and say, okay, here we go. So it axiomatically then follows that what had been done here is unlawful. Because as your ladyship will know, our administrative law has always not asked of administrative organs and the repository of administrative power to act perfectly. Indeed, the administrative process is known for its errors. And if the approach were that if there is an error, no matter how immaterial, that means axiomatically that the court should set it aside. The court will be inundated with such applications. And that is not the law. So the law has always been, well, we permit certain, let's call them incongruities, and the process being review being process related, considers whether or not that had any material effect. Now, your ladyship will know of decisions such as
That's the materiality principle, right?
I beg your pardon, my lady?
It's the materiality principle.
Your ladyship is exactly correct.
It's constantly being applied, yeah.
And so that was the case as far as procurement is concerned always, and we know the last case before All Pay in 2014 was the Museme case in the SCA, where the SCA confirmed that because of issues there of practicality and pragmatism and the nature and the length of extension of the unlawful actions that had been purveyed, the unlawfulness is allowed to stand. Along came All Pay. All Pay just basically said the following. It said that the court doesn't have a discretion anymore when it comes to issue of practicality and pragmatism when there is an identified irregularity in review. The court must declare it as unconstitutional or as unlawful and must set it aside. That is why All Pay brought about the, let's call it the two-stage inquiry. If it's a PAJA review, Section 6 of PAJA deals with that exercise, and if there is an irregularity found, we move to Section 8. If it's a legality review or if it's a self-review, as is probably the case here, it's the principle of legality that applies. And if there is a found irregularity, we go to Section 172 of the Constitution, which entitles the court to make any order that justice and equity dictates. But the point is, in order to determine indeed if there is a reviewable irregularity, the red flag approach is not to be followed. What the court said in All Pay is that the legal evaluation must, where appropriate, take into account the materiality of any deviance from legal requirements by linking the question of compliance to the purpose of the provision before concluding that a review ground under PAJA has been established. The distinction between peremptory and directory provisions has fallen away. Although there are a number of factors that need to be considered in an inquiry into materiality of compliance with legal requirements, the central element is to link the question of compliance to the purpose of the provision. The question is whether what was done constituted compliance with the statutory provisions viewed in the light of their purpose. And that is not the same question as whether compliance with the provisions will lead to a different result. In other words, in sum, what we are dealing with is if there is an irregularity exposed, your ladyship is to weigh that to the paramount considerations in our Constitution. Is, okay, is this irregularity so material in its effect that it does violence to the principles ensconced in Section 217 of our Constitution, that being the ultimate, we respectfully submit, consideration. So whatever your ladyship hears in our respectful submission today on what is an irregularity and what is not should be viewed through that legal prism. In other words, that is to say, yes, if there were irregularities, did it truly do violence to what our Constitution obligates? Of course, we intend to show to your ladyship that there was no irregularity, but it's necessary, we respectfully submit, that the court keeps this in mind throughout in a consideration of, let's call it, the legality leg of the argument. The second principle, my lady, is, and this is superfluous, and forgive me for stating the obvious, but this is in our respectful submission necessary because of many of the allegations that have been made by the SIU on the one hand. On the other hand, many of the contentions that have been raised in the heads of argument and in my learned friends for the SIU's address to your ladyship this morning most eloquently and most ably. Just as an aside, our condolences and certainly our empathy with our learned friend, Mr. Arendse, for his perils. We hope that he does get better soon. Zuma versus the NDPP's case expanded upon what your ladyship will know is the Plascon-Evans rule. And why Zuma's case is so important is it tells us, as Harms DP had written there, that motion proceedings are not there to decide questions of a factual nature. It is quintessentially and was quintessentially designed to ask a court to pronounce upon the legal consequences that attach to a specified and almost admitted range of facts. The principle is one does not approach a court and ask for it to make findings on probabilities, because motion proceedings do not dabble in probabilities. That is not what it is there for. And that is why the rule is, if there is a dispute of fact, the court must look to the respondent's version and decide whether or not that is wholly untenable, wholly untrue, and can be discarded out of hand. Because if the court can't make that finding, the court must accept what the respondent says is correct and decide the matter accordingly. This is relevant.
But Mr. The court doesn't just look at the respondent's version. It also looks at the applicant's version to the extent it's not disputed.
That's
right?
correct.
Yes.
That's correct. Your ladyship is exactly correct. And that is the procedure as it was designed in order to illuminate or delineate, if your ladyship will, what the facts of the matter are. But if the respondent disputes what the applicant says, it is the respondent's version that must be preferred unless the court is able to find that it's clearly far-fetched and untenable and can be discarded out of hand. But your ladyship's pronunciation of the rule is much better than mine. Your ladyship is correct. Thirdly, my lady, and I skip now to the question of the CSD registration. And your ladyship has debated this with my learned friends, certainly, but what we intend doing is just to refer your ladyship to the heads of argument that were filed. And this bears out the interpretation that is proffered by the SIU. And two specific paragraphs we submit is relevant, and why we say that that interpretation cannot be correct, because the SIU says, well, contrary to what the request for quotations had said, contrary to what instruction note 8 had said, that requirement of CSD registration actually meant that you had to be at that stage already registered on the CSD as a COVID PPE supplier. The rules of interpretation I'm not going to bore your ladyship with. It's a unitary exercise. Both Mabatu's case tells us that. Natal Joint Municipal Pension Fund versus Indemeni says a purposeful and business-like interpretation is to be preferred, etc. And one must consider what was known to the legislature or the draft of the document in question during that time. Now, I need not tell the court of the panic that existed during that time, but for purposes of the interpretation, your ladyship is in our respectful submission to keep that in mind. Can I direct your ladyship's attention to the interpretation advanced by the SIU at para 79 of their heads of argument? Now, remember, once again, superfluously, so my lady, forgive me, there was no COVID-19 pandemic in the past. There certainly was no a virus ravaging the world. And there certainly hadn't been a situation where government was forced or asked, indeed, to contract with providers of certain materials in order to curb the spread of a virus. It was all new, it was all novel. And as we all know, government and everybody concerned had learned as it progressed over the course of the months that follow. But paragraph 79, we respectfully submit, sets out why the SIU's interpretation cannot be correct. In the very last sentence, reads as follows with your Levi quote: "It would mean that the state has never contracted with a supplier of a COVID-19 commodity. There would be no telling if the company could provide the goods or that the goods would be of any quality." Now, there would have been no need, respectfully, my lady, for the government to have contracted with any entity in the past, or to create a CSD list even at that stage, because COVID-19 struck us all as a very, very novel and very new issue. So to say that, well, that should, by means of reading in, because it's not there in the requirement, nor was it a requirement of the RFQ, that, well, you had to be registered on the CSD supply list for COVID-19 PPE equipment. My lady, couldn't have been the intention. The intention is always, as is the case with CSD registration mostly, it's a compliant, it's in terms of the Preferential Procurement Policy Framework Act regulations, which sets out certain requirements in order for a tenderer to qualify as a responsive bidder, and that is issues such as tax compliance, local government taxes and rates being up to date, etc. That is why you are able to do business with government, and that is why you must register in order to do so. That's the first point. The second point is...
Let's just test that proposition, Mr. Grobler.
Please record.
Okay, I take your point that the categorization of registration that the SIU has put forward could be problematic because COVID-19 did not exist before March 2020 or earlier, whenever it arose, December 2019. However, I find it hard to ignore that there isn't specialized items that were innovated, especially in relation to what's in dispute here, to address COVID-19, right? It's items that were always in the market.
That's correct.
The issue of scarcity is a different issue, right? I have a problem with approaching the interpretation of the SD requirement from a proposition that any supplier or service provider can supply any product to a government department. I have a problem with that proposition. Because essentially, that's where you're taking me.
Luckily,
that's the SIU case, and it sounds like that's where you're taking. I have a problem with an events organizing company suddenly, supplying medical supplies, as it happened here.
If your
when they are clearly registered as an events supplier.
It's a perfectly, with respect, my lady, it's a perfectly valid point. And if one were being hyperbolic, one could say that, well, if I am registered on the CSD as a provider of legal services, then certainly that doesn't mean that I can render engineering services. And this is an extreme example. So notionally...
And the reasons are quite logical, right?
Yes, they are.
They're skills related. They're around quality assurance and skills. There's no way you'll venture into procuring the construction of a bridge, because that's out of your skills range. That's out of your professional knowledge.
It certainly is so, but in the normal tender process, your ladyship will know that there are other checks and balances that need to be in place For instance, if CSD registration for the building of a bridge is a requirement, I certainly need to be registered. But as far as the further requirements of the tender are concerned, and I'm talking about in order to qualify, simply as having submitted a acceptable bid as defined in Section 1 of the PPPFA, I need to, for instance, dependent upon the tender criteria and requirements, submit registration submit proof, I beg your pardon, of registration with the Engineering Council of South Africa, the one or the other. The point that I want to make to your ladyship is with reference to the second paragraph of the heads of argument. Now, it's up to my learned friends for Eco Green and Mr. Log to convince your ladyship of this, let's call it this question. Luckily for C squared, we don't need to do that, because if your ladyship goes to para 105 of the heads of argument, the SIU 5, it deals with what C squared was registered for at the time of the conclusion of its contract with the minister, the department. And para 1.5.3 correctly records the facts of the matter. And there your ladyship will see, with reference to the record, that my friends had dealt with the fact that on the CSD itself, there was on 23 March 2020, this is 7 days before the conclusion of the contract, the changing of the status or changing of the service, the nature of the services that C squared can render, and was changed. I just quote from here. It was listed to be cleaning and janitorial supplies, medical apparel and textiles, and personal safety and protection. So that, my lady, factually brings it to within the ambit of what would have expected of a CSD supplier with correct registration. So factually, we submit that the question doesn't apply to C squared, because prior to the conclusion of the agreement, it had changed, or there was a change in its registration to include personal safety and protection, because this is what we're about. One must not, respectfully, my lady, and with respect to my learned friends for the applicant, one must not glibly equate what was called for here as being, and I'll deal with that in a moment, medical supplies or surgical equipment. Surgical equipment is a word that loomed large in my learned friends' heads in the interpretation and in their argument this morning. That was not what was required. It was not medical devices. It was not equipment necessary for any medical purposes. It was to be used in the prevention with what was known at that stage of the spreading of the virus related to taxi goers and transport. So it's personal safety and protective equipment. And the point is that factually C squared was registered as such by the time the agreement was concluded. So that takes care, we respectfully submit, of, let's call it, the second requirement for reverting to Regulation 16A 6.4. Fourthly, my lady, the question of the gloves. And respectfully, this is something I must confess that troubled me in my preparation for the matter as well. Because what the SIU says is that, well, Instruction Note 8, let's assume that it found mandatory application, because if it didn't find mandatory application, all parts of it didn't find mandatory application, which would include the exception that para 3 recalls. So in other words, if it doesn't apply mandatorily, one can't say that, well, this part applies mandatorily, but the other doesn't. Luckily, your ladyship need not go there, because once again, if your ladyship just turns to the record, and can I direct your attention to page 244? Your ladyship had asked of my learned friends earlier, I beg your pardon, it's not 244, it is
224, is it?
224, thank you, my lady, 224. This is the appendix to Instruction Note 8 dealing with gloves. Now, as is the case, respectfully, with much of the evidence that has been presented, the SIU has taken a specific figure, and it has said this is to be applied across the board. But your ladyship would have seen from page 224 to 229 that various different forms or various different types of gloves is therein mentioned. And it is there for the reading, but your ladyship will find three things. Firstly, in all instances where gloves are mentioned there, it is either examination gloves, which we know didn't serve the purpose here, it was to be provided to taxigoers, or it was surgical gloves, to which reference is made. And we know that the gloves that were procured here were not to be used for purposes of the performance of any medical procedure, surgical or otherwise. That's the first point. First and second point, I beg your pardon. But the third is the important one. Your ladyship will see on page 224 that for a specific type of glove, the price indicated is 46 Rand. And then it goes to 49 Rand. And then upon a consideration of what the rest of the appendix means, dependent upon what type of examination or surgical glove is required, it goes up from 46 Rand to about 1,096 Rand and 27 cents. Your ladyship will find that on page 229.
Yeah, that's exactly the finding in Zilwa, that yes, cannot be applied blanketly because yes, there are specifications regarding each item that are married to the price, and such a case is not made out here. I don't know what specification these laws are, assuming it applied, assuming I'm with them that it was peremptory. I don't have the specifications to compare which price was, what's the maximum price applicable.
The ladyship is exactly correct, and that was the second point that I was going to make, because if your ladyship goes to page 247, the specification, all that it says, is your ladyship there?
Yes, I'm there.
Thank you, my lady. On gloves, the specification just simply said gloves for the queue marshal to door handles, 100 latex gloves per box, and it says 8,000 boxes. Now, this touches upon what your ladyship had said earlier. We don't know what kind of gloves actually had to be procured, and if we don't know, then we can't bring it to within any one of the categories mentioned in Annexure A to Instruction Note 8.
But I don't even have to get to this annexure, Mr. Krobler. They don't make out that case in their founding affidavit.
What they say is across the board, the department yes, not entitled to pay more than 46 or 49 Rand, and that is it, and that's the be-all and end-all, and that was what happened. And your ladyship, with respect, had seen that. Just lastly, can I turn your attention to page 255? That is the quote that C Squared had provided. I'm not going to deal with that at length, except to say to your ladyship that C Squared had obviously answered the request for proposals as it was formulated. With respect, I believe your ladyship understands our argument as far as that is concerned. My lady, the fifth point deals with the SIU's allegation that the court is to find that no other suppliers had been approached. And much of the SIU's argument, at least in the heads of argument, says that, well, the court should infer corruption or fraud or mala fides or some connection between Mr. Ben Moseme from C Squared and Mr. Muremi, some untoward connection between them, and that C Squared was awarded the contract simply because of dictates or this relationship. And in fact, if the court goes to para 96 of the SIU's heads, this is important because this is what the SIU's argument is on what exactly the evidence reveals. Now, your ladyship, I'm just going to give you the page references, my lady. I'm not going to go there in order to save time. What Mr. Muremi's evidence especially revealed, or his evidence, I'm talking about the interview that he had with Mr. Reddy and Mr. LaRue, is that prior to 30 March, there was a wellness subdirectorate, it would seem, of the department who was responsible for procurement. And it had made all attempts, it would seem, to contact whomever to try and procure items. And they were unsuccessful. This led to Mr. Muremi's exasperation. It led to Santaku and the taxis industry's exasperation. It certainly led upon Mr. Muremi's explanation to the minister, Mr. Mbulula, at that stage's exasperation. And then only at a certain stage, when all other avenues had been exhausted, was it decided to use the Santaku list that was provided, and, for instance, somebody like C Squared, who had submitted a capability to the department beforehand. Your ladyship will see that utterances being made to Mrs. Reddy and LaRue on pages 618, 619, and 637 of the record before you. Of course, my lady, this was backed up, at least in certain instances, by what de Villiers, Renette de Villiers, had said. And she said as much to the public protector. Your ladyship will find the reference to the documents there in para 96 of my learned friend's heads of argument. For instance, 96.5 says, according to the public protector, Mr. Villiers then says that suppliers on HA were unresponsive and lacked stock. That version was also backed up by Majane's statement, which C Squared highlighted in its opposing affidavit. In other words, Muruemi, de Villiers, and Mojane said, well, we had contacted other people, but there was no stock. And de Villiers at a certain stage certainly indicated that those on the list, the transversal list, were unresponsive and didn't have stock. The SIU seeks to get around this to say that, well, this is improbable, because they say there is no proof, for instance, of telephone records or documentary evidence indicating as much. Now, immediately, your ladyship will realize that that submission resonates in a directly opposite way to what the law says is to be done in motion proceedings. Once again, Zuma's case, for instance. It is not for the SIU to ask the court to make findings on probability in motion proceedings. And firstly. Secondly, my lady, of course, your ladyship will remember that all these appendices, Mr. Muremi's interview, Mr. Villiers' affidavit, and the explanation given to the public protector as far as Mutojani and de Villiers is concerned, form part, if your ladyship will believe it, of the SIU's appendices. They appended to the founding affidavit to some 2,000 odd pages. But what they do is they cherry pick certain portions of it and they disregard the other, such as the evidence that was given to them that, well, we did contact other suppliers and they didn't have stock. And that is why we resorted to what we did here.
Mr.
Lady.
Grobler, just on your argument around the approach I should adopt, or rather when applying the Plascon-Even rules, the Plascon-Evens rule, where does, what finding I ought to make regarding how the department went about identifying the suppliers it should source from. Of course, I'd be remiss to single out what you've just submitted in terms of the SIU really, or rather the fact that I should simply accept C Squared's version that that other suppliers were actually approached as backed by the evidence put forward by the SIU and that they didn't have stock, right? Why should I ignore the allegation made that No, I think this applies to ECHO actually. It doesn't apply to your client, right? Yeah, it doesn't apply to your client. It applies to ECHO.
My lady, yeah, I'm not going to answer it. I was on the verge of answering your ladyship's question. Just
no, rather stay clear of it.
Please, please the court. It's not C squared's version, my lady. All C squared did was to say, no, but you are wrong. Look at your own documents.
Yes.
Yeah, that's all C squared did. Obviously, C squared wasn't privy to what happened. It wasn't a party to those events. It's the third party. But your ladyship is correct. It deals with EcoGreen's situation.
Yes.
My lady, I see it is 1 o'clock. Does your ladyship require us to adjourn for a couple of minutes? I'm entirely in your hands.
Yeah, we do need to take a lunch break, I think. The question is, would you like us to do that now, or would you like to carry on perhaps for 5 or 10 minutes and we break then?
If it is all right with your ladyship, I actually need a break. So if I can, our nature calls. So if your ladyship will give me, but if we can make it 20 minutes, I'm happy to proceed thereafter. Once again, my lady, I will never presume to tell your ladyship what to do. We are here at your leisure. As long as you want to take a break, all our request is that be now, please.
Okay, Mr. Aronson and Mr. Smith. How long do you require? We are taking the adjournment now.
Yeah, we also ordered some lunch, my lady. So 1:30.
1:30 is perfect.
That's fine.
That would work for us, my lady.
1:30. Okay, we adjourn until 1:30. Thank you.
Can you please? Thank you. Thank you. We are. Thank you.
Thank you. My lady, we're ready when you are.
Thank you, Mr. Hobland.
Thank you, my lady. My lady, yeah, when we adjourned, I dealt with the point of it being factually incorrect to suggest that other suppliers were not approached, and the dispute that there apparently exists between the parties concerning that is to be adjudicated upon with reference to Plascon, Evans and Zuma's case. My instructor has just asked me, and I'm going to deal with this very briefly, and it deals with the SIU's allegation of some impropriety between Mr. Museme from C Squared and Mr. Muremi. My lady, in our respectful submission, Mr. Muremi's explanation of the events, which I need not remind the court forms part of the SIU's case, clearly reveals that there was no love lost between those two gentlemen. There hadn't been persistent calls from Mr. Museme to Mr. Muremi. What there was a message from Mr. Museme in asking to whom should he speak if he wants to submit a quotation. Mr. Muremi abruptly answered that, well, he doesn't involve himself with those matters and he should speak to supply chain, which triggered on the part of Mr. Museme an apology by means of a return WhatsApp or SMS indicating that he didn't mean any offence. That's the sum total of the evidence in relation to the relationship between them, of course, together with Mr. Muremi's explanation that since 2009, I believe, and in a sports event, they weren't sitting around the same fire. So there's nothing in that. My lady, just the next point, and this probably is unnecessary. So forgive me. Sorry, my lady.
Give me a reference.
I
need a reference.
To Mr. Muremi's evidence concerning
Yes.
the WhatsApp.
Yes.
Lady, can I come back to that? It is certainly part of the evidence bundle, but I'm going to have to go look for it now. I will provide the court with that in a moment. Can I just step down from this for a moment?
Yes, I also need the paragraph of the extract from All Pay 1 that you read from earlier while we're at it.
Well, let me just make a note of that, my lady. The paragraph that I quoted, my lady, was not so much a quotation. It is our submission of what All Pay 1 means. But if your ladyship requires a full argument on what
exactly... Very long judgment, so it would assist me. You can direct me to specific paragraphs, yeah.
I will deal with that in a moment. Perhaps I can quickly find on the record, with your leave, just the reference to the WhatsApps. Yeah, it starts the evidence, my lady, or not the evidence, the explanation Mr. Muemi tenders on page 558. And it goes up to several pages explaining the relationship that existed between Mr. Muemi and Mr. Museme prior. And it stops or perhaps 572. This is the messages to which I referred earlier. 572 and 573 is the response. Your ladyship will find it there. My lady, I also just very briefly, and forgive me if this is unnecessary, just need to deal with the SAPRA argument. I don't know if your ladyship requires any argument on that, because what the SIU does is it says, because the instruction note 8 said if you depart from what these say, the exclusions, let's call them that, if you want to depart from that, what you need to procure needs to deal with and comply with the Department of Health specifications. The SIU equates that to registration under SAPRA and so as to indicate that what was being rendered was going to be a medicine. Now, the answer is clear. That is not what the note says.
Yes,
No.
you would have noted from my engagement that I don't agree with.
I'm not going to be.
I'm still waiting for Mr. Arons to, if he wants to persuade me further with reference to the wording of the national health specifications, then if he does so, I'll give you an opportunity to respond to his argument. But as matters stand, I'm not with him.
Can I just make one submission on that, my lady? Is the Department of Health specification certainly is not dealt with in the founding affidavit or the appendices. Reference is made by Mr.
I've to him.
Yes.
That not said to what extent that, and I mean, that's an onerous requirement on their part, because they would have needed also to have inspected the products.
Yes.
So.
Thank you, my lady.
Yeah.
My lady, the 7th point is the extension contract. My lady, I have a teenager in my house, and my father-in-law used to say to me that a teenager and a Bible don't belong in one house. They are extremely difficult. But if I ask something of her, and if
it depends whether the parents are Christian or not. If they're not, then doesn't it depend on whether the parents are Christian or not? If they're not, then it's fine. There's no issue.
They're much like Jack Russell's, my lady, the dog species. And it doesn't matter if it's the Quran or if it's Tao or the Sanskrit. They are impossible. But why this finds application is if I ask something very particularly cumbersome or strange of my teenage daughter, she has this very, it's like Nietzsche said, the grimace reveals all. She has this very peculiar facial expression where she sort of turns her head and looks at me just as to say, really? And immediately one's response on the SIU's complaint about the extension contract to the rendering of the transport for services lends toward that. Because, my lady, yes, if one views it through the constitutional commandments of cost effectiveness, etc., the SIU seems to argue that what the department had to do there under circumstances where C Squared had secured part of the contract, I'm of course referring to the second round of procurement. What the department was there to do was to again now go and source outside the ambit of the contracts already concluded, to go and source quotations for the transportation of Eco Green and Mistra Logs PPE. C Squared had the ability of doing was being delivered nationally. He simply said, well, in order to save costs, what we're going to do is we're going to deliver those products as well. Now, under normal circumstances, what the department would have had to do was to go and source those quotations. We accept that. But if one considers what Allpay says, and if one considers what the motivation behind it was, and if one considers the authority generally upon the department that was rested upon it under the emergency situation as it existed, the question is whether or not that was unlawful, given what the purpose was of the extension. My lady, with respect, I don't think that this tribunal should concern itself with such questions. It's certainly got much more cumbersome work and important work to do. But to bring a review application based upon that, my lady, with respect, subverts the intention behind the establishment of the SIU and the role that this court is to fulfill.
Mr. Pope, in the absence of quotation, how?
Yes. With respect, my lady, but I believe the question should be answered with reference to the case that my client has been called upon to meet. And I believe I touched on this on the heads of argument as well. If the SIU had come and said, as it had done selectively on instruction note 8, if it had come and said, well, a normal price with reference to this and that practice and this and that, the other, established way of doing about this. The normal price would have been 10 Rand, for instance.
Yes.
And because the department had to fork out 250,000 Rand to C squared, comparing the two aggregates or the two amounts to each other means that this wasn't cost effective. And if that had been the case, then certainly there would have been more to answer to that point simply than the case that is now made, is to say that, well, you didn't submit, you asked for quotations, sorry, you didn't ask for bids, so that axiomatically means it's unlawful. If the SIU had advanced as much, one would have been in a position to evaluate whether or not the cost effectiveness principle had been violated. But the problem is that the SIU has not presented such evidence. It limited its case simply to saying that, well, under this emergency situation, you did not ask for quotations of other companies, and as a consequence, it is unlawful. Whereas Allpay tells us that that's not the question. The question is, under the emergency situation, given the facts what they were, was the measures that you resorted to in this instance and applied factually cost effective? And we can't make that assessment, neither can the court, because the SIU hasn't told us what a reasonable price would have been, or what the normal price would have been. What would company X and Y have charged under the circumstances? So it boils down to the SIU, who bears the onus, we respectfully submit, not making a case for it.
Okay.
My lady, eighthly, requests for quotations were indeed sent out. Your ladyship will find that on page 246. So the submission that there was no quotations asked is wrong, with great respect. Ninthly, my lady, the remedy, of course, in our submission, this is in 246. It's the request for quotations form. I had made reference to it earlier when discussing the gloves issue, but this is the request for quotations form that had apparently been submitted or sent out by the Department of Transport.
Yeah, but where was it sent to? Because the SIU case is that it was sent to these specific suppliers.
Yes. Well, what the evidence reveals is that the people on the list, I'm talking about instruction note 8 list, the appendix, were contacted. They didn't have stock or were unresponsive. Santaku had provided a list, remembering, of course, that the Hlokomela, if I pronounce that correctly, project was almost a joint project between the department and Santaku, and Mr. Muemi said that they had been in a relationship since 2001. They, under those circumstances, the department having failed to procure these items earlier, had said, we know of these people, we give you this list, and you may contact them. And of course, we know that Mr. Muemi had instructed as the DG at that stage that, well, that they be contacted, but also C squared, who was not on the list, that everybody be contacted. And this is exactly then what happened. So in order to find that there was no request.
So if C squared was not on the list, then yeah, why was he contacted?
Because, my lady, C squared had contacted the department prior to that and had indicated a willingness and an ability to render the services and to supply PPE. Mr. Museme says that they had widely marketed during that time that they can supply these items. And your ladyship will remember that Mr. de Villiers, for instance, indicated in her affidavit that she had been inundated with quotations and submissions from various parties. This is quite apart from the Santaku list, to such an extent that she...
So from the others who were not on the list, who initiated contact with the department, was the RFQ sent to them?
We believe so, my lady. There certainly is no question that the RFQ was sent out, and this is the point that I'm trying to make, is that it certainly is so that the listed providers were contacted and C squared and asked for quotations. The point that I'm trying to make is that they were asked to quote, whereas the submission was on the part of the SIU that there was no such a request. The request, the form itself is on page 246, and that is what I was addressing. My lady, the remedy, ninthly, and I'm almost done. We need not go there, my lady, at all, as far as C squared is concerned, and I certainly do not want to put my learned friends for any of the other respondents in a precarious position, but we made the point in our heads of argument that there is a distinct difference between the case made as against C squared and Eco Green and Mr. Log now having fallen out. So if there is an exposed irregularity as far as C squared is concerned, my lady, there is no evidence of turpitude, there is no evidence of malfeasance, there certainly is no evidence of any unbecoming conduct on the part of C squared. So please do not, if your ladyship will, cast them under the same net as the other respondents. There are decisions, my lady, most recently the court, it's an SIU matter. The SCA, I made reference to this at footnote 49 of my heads of argument, my lady, page 25.
I actually saw that judgment for the first time in your heads. When was it handed down?
My lady, it was rather recently. As far as I recall, it was in March.
Okay, yeah.
Yeah, where the SCA said that this court is perfectly entitled to not order any repayment. It's wrong, with great respect, to suggest that if the court finds irregularity, it axiomatically and perforce means that there has to be a repayment. What the court said in Phumelela's case is that the discretion conferred upon the tribunal, as is the case with any court, is a discretion.
Was it a tribunal matter? Was that a tribunal matter? No, I think it's a high court matter. I don't think it's a tribunal matter.
I make reference to two decisions, my lady. The first one is the Central Energy Fund matter versus Venus Ray's trade, and that's at footnote 48 of my heads. And the quotation contained in my heads of argument is extracted from that judgment. And then at para 9.2 of my heads, I referred to the SIU matter versus, I'm going to mispronounce this, my lady, I'm sorry, I think it's Phumela Property Investments. Now, this might trigger an acute sense of deja vu with your ladyship. But that matter went to the SCA as well, and I believe it was in March. And there the court also said that, well, there's no compulsion on the part of a court on the part, or at present, I beg your pardon, a found irregularity to order repayment. The court is to consider all facts. The court is to consider what is.
Yes, of course, the court exercises the discretion. There's no compulsion. It exercises the discretion judicially considered.
Yes.
Right?
Yes, my lady. That's exactly the principle, and your ladyship is exactly correct. That's what the SCA said. So it doesn't, as the SIU contains, that automatically if there is an irregularity, there should be a repayment of any amount. Of course, my lady, and we cannot stress this enough, I make this submission and I deal with this totally ex.
But in Mott, isn't that the principle in Mott Foundation? That is the principle. And in fact, in Mott, what the court did, it even summarized the factors that a court needs to take into account when exercising the discretion on the basis of quite a number of constitutional court decisions, but chief of which is all pay.
Your ladyship, perhaps it's apposite that we deal with all pay 2 now. When all pay came to the constitutional court, it came upon the back of the administrative law procurement-wise as it then existed. And I've dealt with this previously in my argument. And when the constitutional court then said, well, to the extent that the common law allowed for the enduring of administrative acts which were invalid a la Oude Kraal and all those decisions, that is no longer the position. The court is compelled under section 165 to declare the action as unlawful and then go over to the remedy. So it's a splitting of what was something singular in the past into something that is twofold.
Yes, I'm quite familiar with that approach, yes.
Thank you, my lady. And then in all pay 2, but because the evidence in all pay 1 wasn't sufficient so as to enable the court to exercise its discretion and determine what is and equitable, the Con Court actually said, well, go back and give me more facts and give me additional heads and tell me what I should order. And that's where All Pay 2 came in. And that was, of course, the cash paymaster system matter. And your ladyship will remember in All Pay 2, then the court, because of the impact that a declaration of invalidity and axiomatic striking down of the contract would have had on many citizens who were dependent upon these SASSA grants, the court allowed the irregularity to endure for a term, so as to make sure that the department could set out new tenders, follow.
Of course, I shouldn't worry about that here.
Yes.
Right? The facts are clearly distinguishable. Yes.
They are. The only reference, or why I make reference to it, is just to explain to your ladyship, once again superfluously, so forgive me, that it does not necessarily mean that if there is an irregularity that there needs to be a repayment or the contract needs to be struck down. What is to be done is a true exercising of a judicial discretion with regard to a whole host of factors. That's what All Pay 2 says. My lady, lastly, does your ladyship require my opinion or my submissions?
You've not assisted me thoroughly there.
My lady.
So, okay, with respect to the structural interdict that the court issued, the court didn't limit it. Remember, it condoned the irregularity and allowed the contract to continue, right? So the court did not require, and I'll use your preferred interpretation of that jurisprudence, a scrutiny of the profits only in relation to the contract going forward.
That's right.
It was a retrospective, the interdict had a retrospective application, even in relation to the profits earned prior to that ruling. Right?
Yeah, I don't think, my lady, if my memory serves, and I will provide your ladyship with if you so require, complete heads on this. The court in All Pay 1 simply said that what had been done was unlawful as far as the procurement was concerned. As far as I recall, the court didn't grant a structural interdict. What the court said is, I make the declaration, but I allow the parties to go and present further evidence and heads in order to tell me what the just and equitable order would be. And in the interim, the contract will endure. I don't think a profit was...
Well, interdict in the sense of a mandamus. Wasn't preventing anything. It's a directive.
That's correct. My ladyship is exactly correct. So the court didn't truly deal with whether profits should be forfeited or repaid or anything.
I want to know how it all ended, because, you know, from the reported judgment, the court called for financial evidence.
That's correct. That's correct. And I will provide your ladyship with heads on All Pay 2. What the court said is that it will allow the irregularity to endure in the public interest.
Yes. But what I'm putting to you is that the requirement for the directive did not only apply to the contract going forward, it applied retrospectively.
The declaration of invalidity applied retrospectively. That certainly is so. But that was part of the Section 6R.
No, I'm dealing with something different, Mr. Smith, right?
I'm sorry, my lady.
There was a declaration of invalidity, but suspended for practical reasons.
That's
right?
correct.
Was suspended. That's not an issue here at all.
Yes,
then the court orders that the financial statements of cash paymaster should be submitted so that it scrutinizes its. And here's my question to you. That directive did not really apply it didn't only apply to the contract going forward from the date of judgment. It applied from inception.
That's correct.
Yeah.
And there's notionally, sorry, my lady, there's notionally nothing wrong with such an order. I'm talking about applied in carso, of course, because the court is only bound by the constrictions of what is just and equitable. There is no hard and fast rule. The court may look to all the facts, both reactive and proactive, and retrospective and prospective,
Yes.
and then consider all those facts and then make a decision. That's the point.
Yes.
Yes, that's the principle.
That's it. That is of particular interest to me. Yeah, it's of particular interest to me particularly because the court had suspended the declaration of invalidity. Right. So in a way, it condoned the irregularity. As the whatever remedy in the end, it didn't only apply to the period condoned, right, which is the continuation of the contract, even though declared invalid. It applied from inception.
Yes.
So the court required all the information that it considered necessary to allow itself to exercise discretion.
That's no, that certainly is correct. Your ladyship had alluded to it earlier, and with respect, quite
so
correctly.
that is why, for me, I'm really interested in knowing. I'm interested in knowing precisely what was ordered in the end, because it didn't just end. This matter didn't just end with that directive.
I shall, with your ladyship's leave, and of course we are here at your ladyship's leisure and at your service, I shall provide your ladyship with heads of argument supplementary dealing with what the court had done in Allpay, both Allpay 1 and 2. I think that's the best way to go about it, to satisfy your ladyship's question.
Thank you.
Thank you. My lady, the last point is the letter. I beg your pardon?
Oh, yes. Okay, you'd like to address me on Ledler, okay?
Yeah. My lady, yeah, the way I understand it is, and I read Ledler again last night, is what the court was called upon there to decide. I'm talking about the Con Court. And this, in essence, was the crux of the appeal, and it was set out in such a way as well, was whether the tribunal was a court, and we know that question had been answered, and whether the court can grant, the tribunal can hear reviews, that was answered as well. But it dealt with the court's empowerment, the way I understood it, pertaining to two things: whether the court could grant preservation orders and forfeiture orders. I don't believe Ledler meandered sort of off point to the extent to say that this court may not deal with legality reviews or order any just and equitable remedy, whether it's in terms of Section 8 of the SIU Act or if it's in terms of Section 172 of the Constitution. Certainly, I believe my learned friends for the SIU are correct here. To the establishment of this tribunal and the elevation of the tribunal to that status of a court be entirely negated by anything that says the court's arms are bound in the face of an exposed irregularity, jurisdiction-wise, given what Allpay tells us and given what the modern dispensation on matters of procurement dictate. But if
I'm trying to find the relevant paragraph. I think it is towards the end.
I don't have Ledler with me, my lady, but if your ladyship requires it, and as long as we are going to submit supplementary heads, we may as well deal with that as well. I think
it's 69, my lady. Sorry, Stefan.
Not at all.
Para 69, my lady.
Thank you. Thank you. I'm there shortly. No, 69 deals with a different. Okay, there's a specific paragraph that I am looking for. It's the conclusion, the concluding paragraph.
Sorry, my lady.
It says, in the result, the special tribunal is not a court. However, it has jurisdiction to adjudicate legality reviews in terms of the SIU Act.
Yes. I believe that answers your ladyship's question.
Yeah, so it doesn't say legality reviews in terms of section 172, right? Because when you read that judgment, the court said the tribunal is a creature of statute and it may only function within the four corners of that statute. So of course we can't argue, we can't order anything unconstitutional. But my understanding is that we don't derive our powers from the Constitution. We don't.
The doctrine of subsidiarity, with which your ladyship will be familiar, dictates that national legislation is to be enacted to give effect to the provisions of the Constitution. That's why Section 217 of the Constitution says what it says, and the PPPFA is the national legislation enacted to give effect to it. It's much the same with the Bill of Rights and the right to administrative justice granted in Section 30 or 33, I believe, and the enactment of PAJA. So my interpretation of LEDLA simply says that if the court is not a court in the ordinary sense, but it is competent under its jurisdiction to deal with legality reviews, it perforce, and in administrative law, ex consequentibus means that the court may pronounce upon the matter as if it were a court. In other words, the court is not asked to make declarations of invalidity of the Constitution itself. What the court is asked to do is to implement the Constitution, as is the requirement of all courts and tribunals, and to make pronunciations with regard to a specific set of facts measured against the constitutional imperatives. So if it comes to jurisdiction, the way I understood LEDLA, it simply says that the court may deal with legality reviews in a way that any other court may do it, and which includes then declarations of invalidity.
Don't you think the Constitutional Court would have said that? That's not what it said.
I think that's basically what they meant. If your ladyship is of the view that they didn't expressly say it, that certainly is so. But I don't think the judgment can be interpreted as meaning that your ladyship lacks the power to give effect to the purpose behind the enactment of the SIU Act and the proclamation, or to say that your ladyship may hear and decide whether there was an irregularity in procurement-related matters, but in the presence of such a finding may not order any relief subsequent to that. I respectfully, I don't think that's the way to go about it.
Okay, I look forward to your receipt. Will you include?
I will.
Deal with this in your supplementary heads and also
with all
support with authorities.
I will do that, my lady. Thank you.
If you look at LEDLA from paragraph 54, where the court says the question then becomes, can a tribunal, more specifically the special tribunal, conduct a legality review? My reading of the judgment from there going forward it seems to draw a distinction between a legality review in terms of the Constitution and a legality review in terms of the SIU Act.
I think a cause of action, my lady, is probably what is meant with a legality review, and it doesn't necessarily deal with jurisdiction. In other words, if the Constitutional Court said the court can hear a legality review, it may do so under the general powers conferred upon all courts to deal with such a...
No, but remember, we're not a court, right?
Yes.
So you can't say that. We are not a court. And Section 166E makes no reference to tribunals. It deals with the judicial authority of the state, which rests upon Magistrates Court and the High Court and the Superior Courts. Very clear about that. It doesn't rest it on any other adjudicative body established in terms of the Constitution, and that's really where the challenge, the challenge to the tribunal. That's really where the challenge to the tribunal's jurisdiction is rooted in.
My lady,
So this
is
just highlights another difficulty with this judgment. With all due respect to the Concord, I do really hope that the legislature steps in here.
Yeah, my lady, this is, in our respect for submission, an issue which, at least on my part, requires some thought, some thorough thought, and the submission of additional heads. Of course, I would love to tell your ladyship that you don't have jurisdiction, and that will be the end of it. But I don't think I will be acting responsibly if I do. So permit me, if your ladyship
That
will.
wouldn't really assist you, because in any event, as I said, if I'm confined to Section 8.2, then the order sought, to the extent the case is made out for it, is still good.
Yes.
Yeah.
Yes.
But I just need to provide clarity on just make sure that a solid authority comes out regarding the implications of leather.
As long as that applies to the other respondents, as far as remedy is concerned, and not my client, my lady, we obviously have no problem with that. But as the court pleases, I will do my best to assist the court.
Thank
my lady, might I inquire if your ladyship requires anything else of me? I can take your ladyship through for the next hour all the factual inaccuracies in the case made out.
That wouldn't assist at all. That wouldn't assist. I mean, the facts are not complex, but they are elaborate. Right.
The point behind, sorry, my lady.
No,
the point behind such an exposition would simply be to show to your ladyship that the argument advanced on the part of the SIU is based upon, in many instances, the wrong facts. But as your ladyship knows, any case has got what I like to call chaff, and it has got wheat. The wheat facts, I believe, we have addressed. The chaff is not necessary. The essence.
That's how I normally approach adjudication, just to save time. So I don't think there's a need to do that. Thank you, Mr.
For that reason, I'm not going to deal with it. My lady, we ask that your ladyship dismiss this application as against C squared, the first respondent, with costs.
Thank you.
Thank you, my lady.
Mr. Smith.
Thank you, my lady. As it pleases the tribunal. My lady, we've filed a relatively full set of heads of arguments on behalf of the second and third respondents, who I'll refer to as Echo Green. I don't intend to take you through those heads in any great detail. Instead, and with your leave, I would rather highlight and address three main submissions we wish to make. The first of those submissions is that we submit that Echo Green and its sole shareholder and director, Ms. Bimji, are innocent of any wrongdoing or unlawfulness which may taint this tender process. I'll develop this submission by addressing the respects in which the SIU contends Echo Green has acted fraudulently or corruptly, and I'll show that this is simply not the case. My lady, the second main submission we'd like to make is a submission of law, whereas the first submission is one of fact. And that is that even if the contract is declared unlawful, we say there's no warrant for the drastic and draconian relief of the full repayment of the contract price. We say that this would be unprecedented, and by ladyship, you've already raised the fact that the SIU cites no authority in their heads of argument or in oral argument which would support such relief. The third submission, my lady, is another submission of law, and that's, again, that even if the contract is declared unlawful, we say that Echo Green should not be ordered to repay the profits it earned under the contract. My learned friend for the first respondent has made the point that the SCA has recently said that such an order should not be granted as a matter of course against an innocent contractor. And we say that the facts of this case are, in any event, exceptional. Echo Green is a small one-woman run business, and we say it would be disproportionately affected by this relief if it is granted. So we'll therefore submit that even in the event the contract is declared unlawful, there are no grounds to order the repayment of the contract price or the profits earned under the contract. My lady, I do not intend to address in oral argument the allegations in relation to the lawfulness and reviewability of the contract. We have dealt with that in our heads, and we stand by the submissions we make in that regard. Instead, we intend to focus an oral argument on what we say is critical for Echo Green, and that's the relief sought against it. My lady, before turning to our main submissions, with your leave, I'd like to make three further contextual points, one might call them. The first of these points is that Echo Green is a small business. Its sole shareholder and director is Ms. Bimji. And we would say that while some of the facts in this case may have raised flags for us lawyers, we submit that it is important not to impute our level of knowledge, experience, and circumspection to Ms. Bimji. She is a layperson and an owner of a small business. And to the extent that her and Echo Green are to be judged, we say they must be judged with this context in mind. The second point of context we would like to make is that we submit that at worst, Echo Green was an innocent pawn in a broader illicit scheme. And that scheme was conducted by Mr. Buthelezi, the CEO of Santaka, and others, including departmental officials. We will submit that it is obvious that Echo Green is merely a pawn. And the SIU's version is that the funds ultimately flowed to Mr. Buthelezi. It says he used Echo Green as a front. But we say, and this we submit is relatively remarkable, it is Echo Green who is sued in these proceedings. Mr. Buthelezi is not cited, not even as an interested party. No relief is sought against him. And there's also no indication on the papers that steps have been taken against him or the departmental officials, such as the DG, who the SIU alleges were complicit in the corruption. Instead, it is Echo Green, who we say is the smallest and least culpable actor in the story, that is pursued by the SIU in these proceedings. As I said, we submit that this fact is in itself relatively remarkable. The third and last point of context I'd like to make is this. The SIU states in numerous places in its heads of argument and its papers that the point of these proceedings is not to punish Echo Green. We would simply submit that that is precisely the effect that the relief sought by the SIU will in fact have on Echo Green. This is obviously the case if Echo Green is required to pay back the full contract value, but it is also very much the case if Echo Green is asked to return the profits it earned 3 years after the contract has been fully performed, and where it's unclear whether those profits remain with it. So finally, we would say it needs to be seriously considered whether it is just and equitable in this case to order any type of repayment, especially where the real culprits and the ultimate recipients of state funds, like Mr. Buthelezi, are not before the tribunal. My lady, with that in mind, I'll proceed to make our first factual submission, and this is in relation to Echo Green and Ms. Bimji's culpability or lack of culpability in relation to the contract. Before turning to the facts, we'd like to make two broad points. The first is that we accept that culpability is the culpability or lack of culpability of Echo Green and Ms. Bimji is relevant to the merits of this case, but also especially to the remedy. And in that regard, we cite in our heads two cases. It's a recent SIU case, the Pumela property case, and the Central Energy Fund case in SCA. And what those cases say is that our courts distinguish between parties who are complicit in corruption or impropriety and those who are innocent parties. And we accept that trite axiom, and we'll obviously submit that Echo Green and Ms. Bimji are innocent parties in this case. The second point, and I won't go into it in great detail because my learned friend for the first respondent dealt with it, but it's simply, again, to reiterate the rule in Plascon Evans that the respondent's version should prevail and the admitted facts on the applicant's papers, and that is unless, as the SEA says in the NDPP versus Zuma case, the respondent's version is plainly fictitious or palpably implausible. My lady, with that in mind, I'll address three factual issues in relation to EcoGreen's culpability. And the first is the issue in relation to its CSD registration and the allegation by the SIU that the CSU is or manipulated by EcoGreen. The second point I'll make is in relation to EcoGreen's relationship, or as we'll say, non-relationship with Mr. Buthelezi, the CEO of Santaco. And the third point, and this is a smaller point, but it's a point that is necessary to address, I think, is the nature of the products supplied by EcoGreen. My lady, if I then might turn to the first submission, and this is in relation to EcoGreen's CSD registration. And just to highlight the case that EcoGreen has to meet here, the SIU's allegations, and we summarize these in the heads, and they're made in the founding affidavit. They say that EcoGreen fraudulently doctored or manipulated the CSD registration of the second respondent, that's K 2013. And they said it did so on the 1st of April 2020 at 2:57. And they said its registration was doctored so that it made it appear as if EcoGreen rather than K 2013 was registered. So they say that EcoGreen changed the name of the supplier that was listed on the CSD database. And they submit that this was a fraudulent misrepresentation and that EcoGreen won the contract on the basis of this misrepresentation. Now, in fairness to the SIU, and it must be said, these allegations derive from Ms. Bimji's first affidavit, which she deposed to after an interview with the SIU on 17 February 2021. And that's that affidavit is FA20 of the FA20 to the annexure FA20 to the founding papers. Now, the pertinent, Ms. Bimji accepts that that affidavit is correct in all respects, except for paragraph 4.1, which contains the pertinent averments. And for your reference, that paragraph can be found on page 001-758 of the case lines bundle. Now, I'd like to make two submissions in relation to this affidavit and the correct version of the facts. The first is in relation to Ms. Bimji's explanation for this paragraph, and she says it was deposed to an error. And the second point I'd like to make is that in relation to the objective documentary evidence and facts on the SIU's own papers, we say that what is contained in that paragraph was clearly an error and it shouldn't be relied on. Instead, the court, we say, or the tribunal, we say, should rather rely on the version that's contained in Ms. Bimji's answering affidavit. So first, to take you to Ms. Bimji's explanation for her error, and that is made in the answering papers, and it's at paragraph 88 of the answering papers, and that's at page 012-21. Ms. Bimji says that the affidavit was prepared by the SIU after its interview with her. She says she acknowledges that she signed the affidavit. She said she did so in circumstances where she was overwhelmed by the threat of an investigation by the Special Investigations Unit into a matter where she was of the view that she had done nothing wrong. And she said she agreed to sign the affidavit because she wished to assist the SIU and she wished to get this matter off her back. She received no legal advice before deposing to the affidavit, and she subsequently sought to correct that affidavit in a second affidavit which is filed. And if you wish to, my lady, you can find that second affidavit at FA52 to the filing papers. That's at page 001-2117. My lady, and we say it's easy for someone in my position, at least, to flippantly disregard this explanation by Ms. Bimji about why she signed the affidavit. But we would submit that it should be scrutinized carefully, and it should be scrutinized based on the position Ms. Bimji found herself in. She's a small businesswoman. No doubt this was the first time she had come into a situation like this. She was hauled before the SIU. She was intimidated by the interview. I'm not suggesting any impropriety on the part of the SIU, but she was intimidated by the process. The SIU presented facts which in relation to matters that happened more than a year before, and she she thought she was doing the right thing in signing this affidavit. So we'd ask you not to ignore that fact and not to disregard her explanation. But the more pertinent submission we'd like to make is actually the second one, and this we say is that it's clear that the version put up in her first affidavit at paragraph 4.1 and the version that is carried through to the SIU's heads of argument and its filing papers is incorrect on the objective facts and on the documentary evidence that is put up by the SIU itself. So the SIU says in its papers, and I don't need to take you to this because they said on numerous occasions, they say that Echo Green was not registered when the department evaluated the first round of bids on 31 March 2020. And I simply wish to disprove this, and I'd like to take you to a document in the record, and this is an annexure to the SIU's affidavit. At annexure FA 45, the SIU annexes an affidavit by its accountant in relation to the profits that Echo Green earned on the contract, and then numerous annexures which it attaches to that affidavit, FA 45. And I'd like to take you in particular to one annexure, and that's annexure AK 23. I can give you the page reference if that would help you, my lady.
Yes.
It's at page 0189. Says in fact, and next to Echo Green's answering papers, but it's important, I think, in this context to demonstrate that it is a document that the SIU itself under.
Okay, let me just get to it.
Certainly, but would you like me to screen possibly?
Quicker.
Let me see if I can do that. I'm not sure if I have
I'm
access.
almost there, though.
My lady, can you see it?
I can see it, but the text is not legible.
I will zoom for you, my lady. My lady, just for context, I'll zoom into the pertinent part shortly. Just for context, this was, and the SIU's affidavit itself attests to this. This was a CSD report which was extracted by the department's SCM manager, Mr. Villiers, when she was evaluating the first round of bids. You will recall that Echo Green submitted a bid in the first round. And she pulled this out, and you might be able to see in the top right-hand corner, I've zoomed in for you. The report was accessed on the 31st of March, 2020, and was accessed at 9:29 in the morning.
I see that.
Great, thank you, my lady. And my lady, I'd like to take you to the details here. Firstly, the supplier number. That supplier number MAAA09026160. And I can tell you now, my lady, and I can take you to the relevant documents, but I doubt this can be disputed by my opponents. This is the supplier number which the SIU said was allocated to K 2013 and which was doctored on the 1st of April to reflect Echo Green. And then, my lady, you'll see about 6 spaces down, the legal name of the company is recorded there as Echo Green Environmental Consulting, and it's said to be a private company, Pty Limited. So that is, and then across there's the CIPC company registration number, and that's 2013-09. You can see that number there, my lady.
Mm-hmm.
So this document conclusively shows that Echo Green, and with the registration or CSD number, which SIU says was born by K 2013, was registered on the 31st of March at 9:29 in the morning. Now, I would like to take you now to a CSD report pulled the following day, and that is at FA 28 of the papers. I can pull it up for you again. And the pertinent part about this CSD report, and again, you can see in the top corner, it says it was pulled on 1 April 2020 at 2:57 in the afternoon. Notably, that is the precise time at which the SIU alleges Ms. Bimji was doctoring or changing the registration details of K 2013. And if you look, my lady, if you look again at the supply number, it's at the first line. It's the same supply number of on the CSD report that was pulled by Mr. Villiers the day before. The legal name is the same, Eco Green Consulting, Environmental Consulting, and the CIPC number is the same. It's all Eco Green's numbers and Eco Green's details in relation to that supply number. So, my lady, the objective documentary evidence, and this is the documentary evidence that is annexed to the founding affidavit of the SIU, reflects that there was no change in the registration details or the pertinent registration details here of Eco Green CSD registration. Shows that Eco Green was in fact registered on the 30th of March or 31st of March. So there's only two explanations for this document evidence. The first explanation is that there was no change and there was no doctoring on the 1st of April to change K 2013's name to Eco Green. That's the first explanation, and that's the explanation which Eco Green says is correct. The only other explanation in the face of this documentary evidence is that on 31 March, when Mr. Villiers pulled the CSD report, it reflected Eco Green as the entity to whom this supply number was allocated, and that Eco Green then changed this to K 2013 before the 1st of April, and then changed it back to Eco Green on the 1st of April. And that account is obviously illogical, and no one makes those allegations on the papers. So the only logical and tenable explanation for this is that there was in fact no change in the CSD status of Eco Green between 31 March and 1 April. So there was no doctoring. The objective evidence in fact bears this out. And in addition to this, we would, my lady, I'm going to stop sharing if that's okay.
That's fine.
In addition to this, we would point out that the deponent to the department's affidavit, Mr. Villiers, says, and she, it must be pointed out, she's the SCM manager for the department, so someone who should know about these matters and should be acquainted with the CSD system. She says she's not aware that the CSD system could be manipulated by a supplier in this respect. And in that regard, I can refer you to the department's answering affidavit. That's at page 012-14 at paragraph 43. Ms. Bimji, in fact, says the same thing in her affidavit. She says she wasn't aware that the supplier could actually change these details on the CSD system, and that she in any event didn't have the expertise to make these changes. That is why she says in her answering affidavit that the later changes, which I'll get to shortly, were in fact made with the assistance of Treasury and the legitimate assistance of Treasury, who is the curator of the CSD system. So, my lady, we say that puts the matter to bed. The SIU's version simply cannot be correct on its own documentary evidence. It cannot be correct that Eco Green manipulated or changed the CSD details on the 1st of April in order to fraudulently misrepresent that it was registered at the time. And this is also borne out by the fact that Eco Green bid in the first round on the 31st of March. The reason why it failed in the first round bid was not because it wasn't registered or its name didn't appear on the CSD system or because K 2013 was instead registered. It was because its tax compliance certificate wasn't properly uploaded. So even on that version, it's simply inconsistent with the SIU's version that there was a manipulation of the system to ensure that it showed that Echo Green was registered on the 1st of April. We say that's simply untenable on those objective facts. My lady, if I may, I'd like to turn to what we say is the correct version and why the SIU found, when they looked retrospectively at the system in February 2021, that Echo Green had a different supplier number, a different CSD number to the one that it had bid with. We want to explain why that transpired and explain that mistake. Now, Ms. Bimji deals with these details in some detail in her heads, or in her answering affidavit. We summarize them in our heads of argument at paragraph 23. And I'll just go through them quickly. The first point is that she says Echo Green was registered in 2013 through First National Bank. At the time, First National Bank provided a service in coordination with CIPC to assist small businesses to be registered on CIPC and to get a PTY limited. F&B at the time opened a bank account, ostensibly in the name of Echo Green. And then Ms. Bimji proceeded to trade under the name Echo Green and with her company, and used that bank account that was allocated to her from the period between 2013 and 2020, or 2020. In order to apply for the tender and to submit a quote, Ms. Bimji registered Echo Green on the CSD system on 27 March 2020, as was required for the tender. She submitted a quote in the first round on 31 March. As I said, that quote failed, not for lack of registration on the CSD system, but rather because her tax compliance status wasn't updated. She subsequently corrected that. As I said, she uploaded those tax documents and submitted a new bid on 2 April. This was in the second round, and she was awarded a contract on that basis. It then transpired that she was unable to be paid by the department because the CSD system reflected that there was a bank verification error. The bank couldn't verify that the account details she had provided matched the legal name of Echo Green and its company registration number. And that point is made in an email by Mr. Villiers, the SCM manager, on 21 April 2020. I don't know if you want to reference that, my lady. It's another document annexed to the SIU's accountant's affidavit. It's at page 001-1781. Ms. Bimji then sought to resolve this issue by visiting F&B to try and determine what had happened. She visited them on 22 May 2020. She visited their Greenstone branch. And what transpired, and there's documentary evidence annexed to Ms. Bimji's answering affidavit to attest to all of these facts. They're not facts that are simply made up. It transpired that K2013, this alter ego of Echo Green, was registered erroneously by F&B in 2013 when Ms. Bimji sought to have Echo Green registered and sought to have its bank account opened. And F&B then erroneously again allocated Echo Green's bank account into K2013's name. And the reason why this went undetected is F&B, in all of its statements, and I can take you to these if it would be helpful, reflected that the bank account belonged to Echo Green Consulting, Environmental Consulting. So Ms. Bimji acted under the misapprehension that this was in fact Echo Green's bank account and that it was registered to Echo Green and its CIPC number. Ms. Bimji then first learned of the existence of K2013 on 22 May 2020, and she learned of it obviously in consultation with F&B and trying to determine what had happened here. The SIU in its replying affidavit denies that Ms. Bimji could have only discovered this on the 22nd of May 2020, and it cites in this regard, it says, this can't be true because there were recurring salary payments to Ms. Bimji from K2013's bank account. But that explanation is obviously takes the matter no further, because Ms. Bimji was operating for a period of 7 years with K2013's bank account on the apprehension that it was in fact Echo Green's bank account. So of course there were recurring salary payments. So the undisputed evidence is that she first learned of K2013's existence on the 22nd of May, 2020. And notably, F&B admitted that it made an error, and all of this was as a result of its error. And it clarified this in an email to Ms. Bimji on her request. And you can find that email at it's Annexure AA12 to the answering affidavit. It's at page 01257. F&B then proceeded to say that the only way to correct this error, it said it couldn't simply change the name of the bank account from K2013 to Echo Green. It said the way to correct this error was to open a new account, and this was done. And the details of the new account and the confirmation of that new account is Annexure AA10 to the answering affidavit. Echo Green was then obviously left with a further difficulty. It had a new bank account number which it needed to input into the CSD system in order to get paid, because it was no longer K2013's number which was on the system and which generated the verification error. And in this regard, Echo Green approached Treasury and it sought its assistance. And it explained the dilemma and that it needed to input these new bank details onto the CSD registration. Treasury's advice, which they came back with, was that the best way and the most practical and the feasible way to do this was to create a new CSD account for Echo Green with the new bank details. And in order to not have a duplication on the CSD system, to change the name of its old CSD account to K2013, the defunct entity which was erroneously registered by F&B. My lady, and the important fact here is that Treasury itself and not Echo Green effected these changes. Treasury did so on behalf of Echo Green. As the department, as Mr. Villiers of the department alleges in her affidavit, it's simply not possible for a supplier to manipulate these details on the CSD system. That's within the domain of Treasury, who's the custodian of the CSD system. And my lady, this all explains why, when the SIU pulled up or attempted to pull up Echo Green's CSD details in February 2021, it found K2013's details to be registered with Echo Green's old CSD number. That is the simple explanation. So, my lady, in summary, in that regard, we would submit there was clearly no misrepresentation. Echo Green was registered when it bid. That's indisputable given the objective documentary evidence which is annexed to the SIU's founding papers. The second submission in summary is that there was no doctoring, as the SIU terms it, or manipulation of the CSD system. The only changes that were made were the legitimate changes made by Treasury, and those changes were necessitated by F&B's mistake, not Echo Green's mistake. And moreover, my lady, we would submit that there was no intent to deceive anyone. Clearly there wasn't. Echo Green was registered at all the relevant times. It simply later changed its CSD number on the advice of Treasury. And therefore there was simply no unlawful conduct. My lady, so in conclusion on this issue, we would simply say that neither Echo Green nor Ms. Bimji acted improperly at all in relation to the CSD registration issue. My lady, with your leave, I'd like to turn to the second factual issue we want to address. And that's in relation to Echo Green's relationship or non-relationship with Mr. Buthelezi. My lady, in this regard, the SIU says some incredibly strident things, and things which we say can't be justified on any version of the facts in their heads of argument. And we refer to its allegations in this respect in our heads, and we summarize them and provide the relevant references at paragraph 27 of our heads. Just in essence, the SIU's allegations are that Mr. Buthelezi had a financial interest in Echo Green or direct ties to Echo Green, and it takes Echo Green to task for failing to disclose this financial interest and direct ties when it submitted its quote to the department. And it also says, and this is quite remarkable on the facts, it says that Echo Green procured advisory services from Mr. Butelezi's company, Recital Investments, and it purports to rely on Echo Green's own answering affidavit for that averment. My lady, we'd say that none of these allegations can be sustained on any version of the facts. And this is amply explained in Echo Green's answer. And if I might, the Echo Green's answer with the relevant references are conveniently summarized in our heads of argument at paragraph 29. And I'll just take you through them briefly. The first allegation, or the first statement that Ms. Bimji makes in the answering affidavit, and this is a statement with respect that can't be contested. She says Echo Green and her have no relationship whatsoever with Mr. Buthelezi. They say they first heard of him after the contract was awarded and performed. They say that she says, moreover, that Ms. Bimji says she was told by her employer, Ms. Mukoki, of the opportunity to tender and quote for the provision of PPE to the Department of Transport.
I lost you there.
Sorry, my lady, you're quite blurry. I don't know if it's my signal or yours.
Sorry, I think there's something wrong with it. I think it's mine.
Okay.
Mr. Smith?
Yes, my lady. Can you hear me?
Okay. You may proceed. Yes, I can hear you. You may proceed.
My lady, I'm afraid I can't hear you, and your picture has gone distorted. I'm not sure if it's my problem or your problem.
My lady, I think the problem is on your side. I'm not sure if you can reconnect and connect again. I think we lost the judge. I'll just ask her to reconnect.
Thank you so much.
Thank you, Mr. Smith.
Is it not resolved? Is the problem not resolved? Because I can hear.
My lady, your picture's frozen on my side. I can hear you though.
Okay.
The judge is still trying to sort out her connection. She will join us shortly.
Thank you very much.
Thank you.
Thank you.
Okay, is this better?
My lady, I can see you and hear you again.
Thanks for your patience.
No problem at all. My lady, I was simply talking through Ms. Bimji and Echo Green's version in relation to their non-relationship with Mr. Buthelezi. I'd made the point that Ms. Bimji says that her and Echo Green had no relationship whatsoever with him, and in fact, only first heard of him after the contract had been awarded and performed. The next point I was going to move on to was that Ms. Bimji was then told by an employer who employs her, I think, in an event management function, Ms. Mukoki, about the opportunity of tendering and quoting for PPE to the Department of Transport. And Ms. Bimji is an entrepreneurial small business woman who took this opportunity up. Ms. Mukoki also referred Ms. Bimji to Mr. Shivambu, Mr. Musa Shivambu, who she said would be able to assist Ms. Bimji in implementing and responding to this tender. And Ms. Bimji, obviously, given her inexperience in the area, was receptive of this and needed some assistance and took his assistance. Now, the important point here is that Mr. Shivambu is not a shareholder, a director, or an employee of Echo Green. He was at most an independent contractor who assisted Echo Green in the execution of this tender and quoting for this tender. Another very important point is that Ms. Bimji and Echo Green were not aware of Santaco's list, which had been submitted to the department. Now, Echo Green anomalously finds itself on that list. It's anomalous because Ms. Bimji and Echo Green knew nothing of the list. We surmise in our heads of argument, and this is only a surmise because there are no direct facts on this, that Ms. Mukoki or Mr. Shivambu at least knew of the list and had somehow engineered to have Echo Green included on it. And this is suggested to some extent by the fact that Mr. Shivambu is anomalously, again, listed as the contact person for Echo Green on the list, which is anomalous, obviously, because he is not a shareholder, director, or an employee of Echo Green, and was, at the time the list was given to the department, unknown to Echo Green. But the important fact for present purposes in relation to Ms. Bimji's culpability was that she had no knowledge of this list and that it found its way to the department and that her company, Echo Green, was on it. Mr. Shivambu then assisted her in quoting for and executing the contract. It was executed and performed in full. The department received the products. There's no dispute that they didn't get what they quoted for. Mr. Shivambu, in relation to his services provided to Echo Green as an independent contractor, was entitled to receive payment for what he had done in this process. His request to Ms. Bimji was that a payment of 220,000 Rand, which was a part of what he was owed in terms of the services he provided, should be paid to Recital Investments. And this is the company of which we find later Mr. Buthelezi is the director. Now, Ms. Bimji explains in her affidavit that Mr. Shibambu justified this payment. He said he asked expressly that his remuneration be paid to this company. He said that this company, Recital Investments, had provided him with advisory services in relation to a separate business transaction. And in essence, he asked that this payment go to them in order to settle his own debt. But the important point here is that the SIU says, remarkably, we say, and they base this on Ms. Bimji's affidavit, they say Recital Investments was paid for advisory services it rendered to Echo Green in the execution of this tender. Now, that is simply not the case, and there's no allegations on oath which could justify them stating that in their heads of argument. Ms. Bimji's version, which is the only version in this regard, is that Mr. Shibambu asked for the payment in relation to advisory services rendered to him on a separate business transaction. So it was not in relation to this tender. And again, the important fact here is that
very bizarre, Mr. Smith. These facts are extremely bizarre.
I concede, my lady, it is a very strange and illicit scheme that was conducted. The SIU alleges that Ms. Bimji and Echo Green were used as a front. I think that's probably an accurate description of it. The important fact, though, is to the extent that they were used as a front, they were used as a front unknowingly. Ms. Bimji did not know of the Sintaka list. She did not know of Mr. Buthelezi. She did not know that the payment was made to his company. And this is what we say is anomalous about this this litigation and the relief sought against Echo Green and Ms. Bimji. If they are culprits here, and if they are wrongdoers, the wrongdoers are who the money ultimately flowed to, and that's Mr. Buthelezi. He's not on the papers here. Mr. Shibambu is not on the papers. Departmental officials are not on the papers. There's no indication.
The entity that was awarded the contract, the entity that was paid by the department is cited.
Correct, my lady.
I don't even have to find any culpability on behalf of Ms. Bimji.
Agreed, my lady. We accept that
these factual matrix, this factual matrix as against Echo Green is very bizarre, very, very bizarre.
My lady, we accept that it is a strange and unique situation. We would say, and we make the submission sincerely, that on the papers as they stand, it's very clear that Ms. Bimji was an innocent pawn in this wider illicit scheme.
Would you agree that they fall into the categorization of far-fetched allegations?
I would certainly not agree, my lady. My lady, the respondent's version is as I've described it. It's that Ms. Bimji and Echo Green were advised of this opportunity to tender. They tendered for it, as any small entrepreneurial business did. They were advised by this Mr. Shibambu. And Ms. Bimji says on oath on numerous occasions that she was not aware of Mr. Buthelezi or who he was, or that Recital Investments was his company, until long after the contract was awarded and executed. And we would say that that version is not far-fetched or untenable or palpably implausible at all. It's in fact quite consistent with a version that Echo Green was used as an innocent pawn in the broader illicit scheme by Mr. Buthelezi, at least, and departmental officials. So we would submit strenuously that EcoGreen's version must be accepted on Plascon Evans, and that its facts as alleged are not palpably implausible or fictitious or far-fetched. We would further submit in summary that what must be accepted on the papers as they stand is that EcoGreen has no relationship with Mr. Buthelezi. Because it had no relationship, it was not required to disclose that it had such a relationship when it tendered for the goods. There was no relationship. And what is entirely unsustainable on the papers is the SIU's allegation that it procured advisory services from Recital Investments. Plainly did not. At most, as the point I've made, is that EcoGreen was used as a front by Mr. Buthelezi, Mr. Shibambu, and departmental officials in order to improperly benefit themselves. And we say that that factual version is perfectly tenable and perfectly plausible, and is in fact the factual version which should be accepted on the papers. So our concluding submission in relation to this aspect of the facts is that we would say that EcoGreen was, again, not involved in any impropriety or corruption. At most, it was an innocent victim in a border corrupt and illicit scheme. And again, in this regard, I would go back to the contextual submission I made. In our position as lawyers and potentially experienced business people, some of these facts may have raised flags for us, but Ms. Bumji is not in that position. She's a small business person who takes these opportunities, takes opportunities she can to advance her business interests. She wouldn't necessarily have flagged the same things that you or I about it. So we submit that the facts demonstrate that she is not involved in any of the impropriety or corruption in relation to this tender. And lady, the last factual submission I'd like to make is simply in relation to the SIU's allegation. They didn't mention it in their oral address, but I assume they persist in it. And that's the allegation that EcoGreen, in fact, supplied hand sanitizers instead of disinfectant dispensers. And it bases this allegation on a supplier invoice it found among the documents, which refers to hand sanitizers and not disinfectant dispensers. And we deal with these allegations at paragraph 34 of our heads of argument. And the response in this regard is relatively simple. EcoGreen says the supplier's invoice was clearly wrong. EcoGreen says in its answer it still has in its possession some of the disinfectant that was ordered. It was obviously open to the SIU once it saw this allegation to go and check that sanitizer / disinfectant. It didn't do so. But more pertinently than that, the department accepted the product supplied by EcoGreen as meeting the specifications and the quotes that EcoGreen submitted. And in this regard, I would like to refer you to an allegation made in the SIU's own founding affidavit. And that's at, you needn't go to it, my lady, because I can read it to you, but it's at paragraph 127 of the founding affidavit. And that's at page 001-57. And the department says there, Mr. Villiers certified that all goods were received in good order. So the department, the party that ordered these goods, certified that the goods that were provided were the goods that were quoted for. The SIU provides no other evidence that hand sanitizers and instead of disinfectant dispensers were provided. So we say that's simply the end of that submission they make on their papers, and that allegation must be rejected on Plascon Evans. Lady, just briefly in summary in relation to the facts, we would submit that the following must be accepted on the papers. The first thing we say should be accepted is that EcoGreen did not fraudulently doctor the CSD system or misrepresent its registration. The second submission we say should be accepted is that EcoGreen had no relationship with Mr. Buthelezi, and any payment made to his company was made in good faith and without knowledge that it was going to him and that he was involved somehow in the tender process. And the third fact, which we say should be accepted, is that Echo Green supplied the product quoted for. So in sum, we would say that Echo Green falls into the category of an innocent contracting party and that it wasn't involved in any corruption or impropriety or wrongdoing. My lady, if I then might turn to just an equitable remedy, we obviously submit in our heads of argument that the award was not unlawful. If that is correct, there's obviously no need to consider the question of remedy. But if it is unlawful, the question obviously arises. What is the just and equitable order that the tribunal should make in the circumstances? And my lady, I can address you on Ledler if you would like. I can do it now or at the conclusion of my address, but I would proceed on the assumption that the tribunal's discretion in this regard should be guided by what is just and equitable in the cases that underpin that assessment. My lady, the SIU seeks two types of relief. The first and primary relief they seek against Echo Green is the full repayment of the contract price. The second and alternative relief they seek is repayment of profit. So turning briefly to the primary relief they seek, this is the full repayment of the contract price. And my lady, you dealt with it in response to my learned friend for the applicant briefly, but in essence, the SIU claims that Echo Green should pay back the whole 8 million of the contract award, and that even though the department is not ordered to return any of the goods, and they invoke the axiom fraud unravels all. Now, we obviously submit that any allegations of fraud and corruption and impropriety are false, and that should be the end of the matter insofar as this relief is concerned. But we'd like to go further than that. We'd say, even if there is a finding of some kind of impropriety on the part of Echo Green, this remedy is clearly incompetent on the facts of this case. We've made the submission in our heads of argument that this sort of order is unprecedented. The SIU also, as our ladyship pointed out, cites no example of the case where such an order was granted. The only cases we were able to find, and we embarked on a search in this regard, where such an order was granted, were cases where there was either no contract or there was no contract and the services and goods weren't in fact provided. So those are clearly cases that are disanalogous to the present one, where the department received the goods, accepted they met the specifications. There was no suggestion that there was overpricing. So those cases are clearly disanalogous to this one. So we say that the order would be, an order of a full contract repayment would be strikingly unfair. And even if it was premised on an allegation of fraud, the department would obviously be equally implicated in that fraud. And in the circumstances, to order the full repayment would be to provide the department with a huge windfall and effectively unjustifiably enrich it, and to leave Echo Green out of pocket. My lady, and we do cite in our heads of arguments the full bench's decision in the Siangena case, and we cite that at paragraph 76 of the heads of argument. Now, in that case, there was a finding that the tenderer in question was engaged in some kind of impropriety, and the court held there, it said, it must be borne in mind that the work was executed on the applicant's instructions, and as such, it would be just and equitable for the respondents to be paid for the work that they had executed on those instructions. So that's consistent with our submissions in this regard, that it would not be just and equitable to order full repayment of the contract price. My lady, and we also refer in our heads at paragraph 80 to this tribunal's judgment in the Treasury Free State. I won't cite that to you because I believe you were the presiding officer in those proceedings, but that's cited at paragraph 80 as our heads, as I say. So, my lady, we would say that the prayer for the full contract price was both factually and legally unsustainable, and that the order sought would not be just and equitable in terms of Section 172 of the Constitution, 172(1)(b). Turning then to the last submission we wish to make on the law, and this is in relation to the relief, the request for the repayment of EcoGreen's profit. Now, the SIU submits in its heads of arguments that the default rule is that a contractor must return profits earned from a contract declared unlawful unless exceptional circumstances dictate otherwise. This is commonly referred to as the no profit principle. And they say that this derives from the Constitutional Court's decision in All Pay 2. Lady, in this regard, starts in my heads the recent decision of the Supreme Court of Appeal in SIU versus Pumela. We deal with that at paragraph 90 of our heads. I don't know if my lady has had a chance to look at the judgment in detail, but I can summarize its import. The SIU effectively says that this view of the law, that there's this default rule that a contractor, even if innocent, must return its profits except in exceptional circumstances. The SIU says forthrightly that this is incorrect. It says, firstly, that All Pay 2 did not establish the principle that an innocent party is not entitled to retain a profit it made under an invalid contract. And it says that at paragraph 18 of the judgment. It says that this follows from a contextual reading of All Pay 2. It points out that in that case, CPS, the tenderer, was not required to pay back the profit. And my lady, you referred to, in my learned friend's address, ascertaining what happened at the conclusion of that contract, whether there was any order to return the payments. I can refer you to what the SCA says in this regard. And the SCA says, and it's from paragraph 16 of the SCA's judgment. The SCA points out, having looked at the subsequent matters, that there was no order ultimately for repayment of the profits from CPS, the successful tenderer in that case. So the SCA concludes, and this is what it concludes at paragraph 19, it says that the so-called no profit principle is no principle at all. That's what it says. That's a quote. And in doing so, the SCA expressly overruled the High Court in Mott MacDonald, and it also expressly overruled its own decision in Central Energy Fund, and it described both those decisions as clearly wrong. And it makes that submission, or it makes that finding at paragraph 19 of the heads. And then I think the SCA makes the important observation. It says at paragraph 20, it says it's unwise to elevate these dicta in relation to remedy and remedial determinations to rules or principles. It says the discretion must be exercised on a case-by-case basis. My lady, in relation to the SCA's decision, we would make two submissions. The first is we would say that the tribunal is bound by the SCA's decision. The second submission we'd make is that the SCA's decision is clearly correct. And simply to make 3 points on the back of All Pay in this regard. The first is that, as the SCA said, All Pay 2 in its sequel cases, the Court did not apply the principle that it allegedly established, or which the High Court in Mott MacDonald or the SCA and Central Energy Fund said it established. CPS was an innocent tenderer in the case. If it had established this no profit principle, which requires a default rule that even innocent tenderers should return their profits, one would have expected two things in All Pay 2. One would have expected one of two things. The first is you would have expected an order that CPS repay its profits. There's no such order made in the case. Alternatively, you would have expected an explanation in the judgment why CPS should not pay its profits. You don't find that explanation anywhere in the judgment. So we say a contextual reading of All Pay.
Which judgment are you now referring to? All Pay 2?
All Pay 2, my lady.
Well, I'm not surprised that that explanation is not there, because it was premature for it. when looking at the order in All Pay 2?
My lady, with respect, it wasn't premature to it in respect of what the time that had already passed under the contract. By the time the matter was heard in the Constitutional Court, 2 years had elapsed already in the tender. So those were 2 years in which CPS could have been earning a profit. If the ConCourt had established this retrospective no profit principle, which required a party to an unlawful contract to, as a default rule, pay back its profit, one would have expected an order from the Constitutional Court that in relation to those 2 years that had preceded the ConCourt's judgment, CPS should either pay back its profit or an explanation by the court why it shouldn't in the case. So we say that that is the correct contextual reading of all pay. And that's reiterated, as the SCA points out, in the sequel judgments, where you don't find in any of those judgments in order to the effect that CPS or cash paymaster, as their full name is, should repay the profit it has earned in executing the tender. My lady, the other point we'd make in relation to All Pay 2 is that we'd say the statement was made in the context, and I think my learned friend from the first respondent made something like this point. The statement about a tenderer's right to retain a benefit was made in the context of All Pay 2 temporarily extending an unlawful contract. It said to CPS, if SASA goes out for a new tender and isn't able to award a tender or deems it infeasible to award a tender, then there should be public scrutiny about the profits that CPS earns under the contract. And my lady, you were right to point out that the order in relation to the disclosure of CPS's profits was both retrospective and prospective. But it was an order made in relation to the decision of the court to extend an unlawful contract, in other words, to perpetuate the unlawfulness. And in those circumstances, the court said there needs to be public scrutiny of the profits that the tenderer earns in what is, we declare, an unlawful contract.
You know what I find very confusing about when one looks at the ConCourt jurisprudence regarding whether All Pay establishes a no profit, no benefit principle, no loss, no profit, right? No loss, no profit principle is, and I think these are subsequent decisions. I'm speaking under correction because I've not refreshed my mind. Gijima and Buffalo City, where the ConCourt allows the retention of profits in exceptional. So it didn't just apply discretion, it found exceptional circumstances, right? Which impliedly, what does that imply? There's a default position, doesn't it? Because there it looked for, so you're not saying here there are exceptional circumstances, which is the approach in Buffalo City and Gijima.
Yeah.
You're not saying here there are exceptional circumstances to allow my client to retain.
My lady, we're saying two
So
things.
the jurisprudence is really muddled up here. And the SCA itself, I mean, the latest decision, I don't find it of assistance because it contradicts its earlier decision. So why must I be bound by this one and not the earlier one?
My lady, just in relation to our submissions, we make 2 points. We make one, the first point is that the so-called no profit principle has in effect been overturned by the SCA. And the second submission, which we'll proceed to, is
SCA overturned ConCourt.
Apologies, my lady. Sorry, I didn't hear you.
Are you saying the SCA overturned the ConCourt decision?
Not at all, my lady. I'm saying the SCA authoritatively interpreted a ConCourt decision. The SCA didn't purport to overturn the decision.
But there's two interpretations from the SCA. So which one prevails?
My lady, it's the later one that prevails, and it prevails for the reason that it's in the later decision, the court found that the earlier decision was clearly wrong. And in those circumstances, it's well established that a court can not follow its own precedent where it regards that precedent as clearly wrong.
And does it deal with Gijima? I've not looked at that judgment. Of course, I'll study detail. Does it deal with Gijima and Buffalo City?
It deals with both those cases, my lady. And my lady, we would say Gijima and Buffalo City don't bear on this question at all. There's no affirmation in Gijima or Buffalo City that there exists this no profit principle. It might have been exceptional circumstances in that case, in those cases, but there's no suggestion that there is this no profit principle, which generally requires an innocent contractor.
It is implied, because the court said there are exceptional circumstances here that justify the retention of profits, which would mean where there are no exceptional circumstances justifying the retention of profits, then profits should be retained.
But my lady, with respect, we would say that in neither of those decisions they deal expressly with the no profit principle. We don't. There may have been a justification in both of those cases that the circumstances were exceptional and that therefore that justified the relief in those cases. But we would say that it doesn't justify the proposition that there's automatically this no profit principle which automatically applies even to innocent contractors. And my lady, if I might make one last submission on all pay, and this is...
And in Buffalo City, or is it Gijima? Which matter involved the police contract? I think it was Gijima. Gijima involved the police contract. There was no malfeasance, no bad faith, no malfeasance.
Correct, my lady. But that's exactly the point we'd make. That in circumstances where there's an innocent tenderer who's not involved in the malfeasance or any corruption, then in those circumstances, there's no default rule that tenderer should be required to repay.
The point that I'm trying to make is that that factor was not found to be exceptional. The factor that was found to be exceptional was to compensate Gijima for a contract cancel which was regularly awarded. So the fact that Gijima was an innocent party was of no moment. In fact, in most of these cases, there's no evidence of malfeasance or bad faith. But the state is losing millions and millions of money that are intended to benefit the poorest of the poor in this country due to procurement irregularities. And I'm not saying here any type of malfeasance, due to procurement irregularities. And personally, I'm of the view that, if you look at what happened during all pay, we were not living in an era of endemic corruption, endemic maladministration like we do now. The seepage is just too much to allow profits to be retained under these circumstances. Look at COVID, just this cohort of cases. The irregularities were endemic. Money lost to the state is a lot. And should, there be no recovery simply because they're innocent parties. And hence, I firmly believe that the no profit, no loss principle is in most of these cases just inequitable, because nobody is entitled to benefit from a state tender. If they are put in a position they were in before they tendered, that serves the public interest because they haven't lost. But the state shouldn't be losing money because there's endemic maladministration.
My lady, I could not be more sympathetic to your sentiments around the endemic corruption and that we find ourselves in
maladministration. Let's just be sensitive to the parties here.
Certainly, my lady.
Because your case is that there's no evidence of corruption, and I'll have to make a finding there.
My lady, just to clarify, our submission is not that there's no evidence of corruption necessarily. It's that our client, Echo Green, was not in any way complicit in that corruption.
If there was.
Correct, my lady. My lady, in that regard, and as I said, I could not be more sympathetic with your sentiments.
And this is one case, and I've always exercised that boldness, because these decisions that you rely on, all pay, of course, the latest SCA one, I've not read it. I don't know if the SCA made this consideration in the public interest. That's just too much money, which is meant for the public good is lost to maladministration. And that is a factor that needs to be considered when it should weigh heavy when one consider remedial relief.
Certainly, my lady. My lady, I would just like to make two submissions in relation to what you've said. And the first is, in order to pay back the profits, especially 3 years after a contract has been completed and all the services have been provided, is with respect a punitive order on an innocent contracting party. And it is in this respect. Take, for example, if I was given a brief by the state attorney in 2020 and I earned 100,000 Rand off that brief and 80,000 Rand of that was profit. I can assure you that 3 years later, that money would have been spent by me either in reinvesting it in my practice, buying textbooks or the like, or buying a computer, or it would have been spent on my family, buying my baby's nappies or something like that. That money almost invariably, and especially in a small business like Ms. Bimji's business, is not simply sitting in the bank account 3 years later. When the tribunal or court makes an order to repay profits, that will almost invariably, and that's a submission we'll return to now and talking to exceptional circumstances, will almost invariably put a party out of profit and may indeed, in a small business like this, push a party into liquidation in circumstances where
I'm not sure if that argument actually favors your client, because these entities are supposed to be going concerns, isn't it? So one should not assume that they do one sort of tendering and then they leave on the profits for the rest of their lives. They're supposed to be going. They are supposed to be going concerns.
My lady, for that may well be the case for a multinational business. For a large company, it almost certainly isn't often the case for a small company. 1.7 million Rand is the profit figure in this case. 1.7 million Rand might seem trivial to some of the advocates on this court. It certainly isn't trivial to me, and it certainly isn't trivial to Ms. Bimji. And we can take a look at her bank statements, which are annexed to the answering affidavit. It's very clear that this is not a company which has millions and millions of Rand. So in order 3 years later, assuming, for instance, that you find that she was a completely innocent party and that Echo Green was innocent, in order 3 years later, that despite their innocence, they should pay back 1.7 million Rand is a severely punitive order, which may well ruin their business. And we would submit not that this somehow defeats the no profit principle, but that demonstrates in this case, in relation to this small business person, the small businesswoman, that these are exceptional circumstances which warrant a departure from any type of strict rule. So our submissions in this regard, my lady, are twofold. The one is that we would say, with the greatest of respect, that you are bound by the SCA's decision in SIU versus Pamela. And the second submission we'd make is that even under the old no profit principle, which has been applied by our lower courts and even the SCA and Central Energy Fund, we would say that there are exceptional circumstances warranting a departure from that default principle. And my lady, if I might just briefly take you through the factors which we say justify that this is an exceptional case, which would warrant a departure from that principle. We summarize these at paragraphs 94 to 96 of our heads of argument. The first point we make is that we say Echo Green is innocent of wrongdoing and that the allegations to the contrary are incorrect. I know that in terms of the old no profit principle, that in itself wasn't enough, but that must at least be a relevant consideration, we would say. The second point we would say is that Echo Green was not aware or responsible for any of the corruption, such as there was. It was at most an innocent victim and not a perpetrator. The third allegation we'd make is that there's no allegation on the papers that the products delivered were not fit for purpose. It is accepted that they were used by the department in the taxi industry. We'd also state that the products were supplied at market-related prices and at a discount in respect to the masks in relation to Instruction Note 8. There's certainly no allegation that excessive profit was earned by Echo Green or Ms. Bimji, or that they received any undue benefits in relation to this contract. And the third was not the third, the last submission we'd make in this regard, and this really goes to the exceptional circumstances, is that we say an order of repayment of profits, 1.7 million rand here for a small business, would have a disproportionately harsh effect on Echo Green. I've made my points about profits in relation to a small business, but this, in order to this effect, is very unlikely to be able to be sustained by a small business, as opposed to a multinational or a large BTY Limited or a listed company even.
But have you considered the position of an indigent family in some rural area that has school-going children who go to a school with pit latrines, and that family survives on a singular income in the form of an old age pension grant of some gogo, who's the only person in that family who derives some kind of income? So the reliance of such a family on state welfare is disproportionate to your client.
My lady, I obviously can't dispute that, and that is the only problem with
and that's why, with respect to our superior courts, they may not have a huge appreciation of the implications of the cost of maladministration in a manner this tribunal would have, because this is what we see daily, the seepage of money under these circumstances.
Lady, in that regard,
this tribunal has been established to put a stop to it, right?
Correct, my lady. My lady, in that regard, I would like to make this submission, and that's that there's no allegation here, and as I've said, that Echo Green charged excessive prices. In fact, the only evidence is that it charged market-related prices. So the fact of the matter is that if the department had bought these goods in terms of, assume for a moment that you find the procurement process was unlawful and that there was corruption and the like, there's no evidence that the department made a loss here. It's the only evidence is that if they'd gone out in terms of a proper procurement process, they would have paid exactly the same or more for this product. So there's no loss to the fiscus in relation to Echo Green's provision of services.
But what we know is that there's a portion of the money that was paid by the department on your client's version, which is used to sustain another project.
Certainly, my lady, and that's actually the last point I'd like to make.
So what does that mean in terms of the cost effectiveness of this project? If your client affords, the profits are so generous that he's able to employ part of the profits to another project.
My lady,
it doesn't do so to sustain this business, to sustain the business of Echo Green, yes, but it actually finances another project that has nothing to do with the impugned contract.
My lady, what project are you talking about in that regard?
The payment that was made, your case is that it was paid in relation to another service, right? Is that not?
My lady.
Yes.
My lady, that was a payment for services provided to Mr. Shibambu. And in that regard, we would say that that's another reason why these circumstances are exceptional. We say it's disproportionate and unjust when the real perpetrators of any corruption or malfeasance here are not before this court. The evidence is that if there was money that was misspent or misused here, it was the 220,000 rand that went to Mr. Bordelezi. He's not cited in these proceedings. There's no suggestion in the SIU's papers that they've proceeded against him in any way. He's undeniably the corrupt party here, if there is a corrupt party, and not our client. We would say that renders this case exceptional, and that in the circumstances, our client, our submission is that she was entirely innocent and not involved in any corruption or impropriety, that she should not be penalized in effect for the conduct of parties who are not before the tribunal. We say that those are exceptional circumstances which, should the court apply the no profit principle, which the SCA has recently overruled, then this is a case in which it should that warrants a departure from those principles. My lady, are you with me? You seem to have frozen.
I think we have lost the judge, Mr. Smith. Just a minute.
Thank you.
Okay, I seem to be battling with the network.
Sorry, my
Perhaps
lady.
it's a sign that we should be concluding. Anything further from your side, Mr. Smith?
Certainly, my lady. We would just conclude. We'd say, in relation to the relief, we'd say it's manifestly not just and equitable to order a repayment of the profit, and that even under the old test of exceptional circumstances, we say that there would be no warrant for such an order. My lady, just briefly in respect of costs, we say if Echo Green is successful in resisting the remedial prayers of the SIU, it is the SIU that should obviously pay its costs, as this would represent substantial success, even if the contract is ultimately set aside. And we would say that even if Echo Green is required to pay back the profits, it should also not be required to pay the costs, but the department should instead, because in those circumstances, if the tribunal was to find Echo Green was an innocent party, it would be the department's misconduct, well, not necessarily misconduct, but irregular processes which would have resulted in the order of repayment. My lady, just briefly in conclusion, I don't know if you would like me to address you very briefly on Ledler and how we would view it.
Please do so in your supplementary heads in the interest of time.
Absolutely. My lady, just simply in
Because
conclusion.
you've intimated your preferred interpretation of Ledler. I think you have alluded to it, yes.
Yes, my
okay,
lady.
I'm gonna.
My lady, if I might just
yes.
say.
Thank you, my lady.
Good afternoon, Justice.